in, shall we? So we're going to be talking about the EU AI Act today and what it's going to mean for your business. So practical advice, and we're just going to dig into what it actually is and why it applies. So first of all, Piers, could you give us a bit of background as to where the EU AI Act came from? We're going to have problems with that.
A bit of context. Yeah, sure. Yep. No problem at all. So obviously, AI for all of us now is ever present, and but actually the EU have been thinking about this for a little while, and the AI has been around as a concept for a lot longer than that. But proposing this 21 before anyway, or certainly many of us had heard of ChatGPT, and it has finally reached the stage and is now in force with staggered timescales for the rollout. It was published in March this year, and we are now looking at, say, various milestones to get the law to come into play over the next 6, 12, 24, and 6 months. And the is to effectively put in place the first piece of the comprehensive legislation around in the world, and it is trying to balance protecting the fundamental rights of individuals, humans, against innovation. And obviously, time will tell to what extent they have succeeded in that. But we will see, and hopefully, as to the course of this hour, we'll see, to what extent it's going to have an effect on people's businesses.
Okay, great. No, thank you, Piers. I don't know if anybody else, could you put in the comments, please, if you're also hearing? So, Piers, I think we're having a little bit of problems with the internet. Your side, it keeps on cutting out. I'm not sure if anybody could just put in the comments. I can see the comments. I can't reply back to them, but I think we'll be okay. It kept on going in and out, but I think we'll probably be all right. Just as a note. Okay, brilliant. So, one of the big questions I keep on asking is, keep on being asked, isn't it just for EU citizens? There's a lot of people from the UK on this call. We were looking at all the people, got 245 people. Are we getting, it's static a little bit. It is a little bit breaking up. Hopefully it will get fixed. Bit jittery. Generally we can, okay, there's a lot of people saying the same thing, sorry. A lot of people saying this, you're breaking out, Piers, but hopefully if you go slowly, we should be able to kind of still hear you. We'll work through it. But yeah, so isn't it just for EU citizens? As a vast majority of the people here are from the UK. So does it apply to us? What's the situation there?
Yeah, and that would be a really easy, and we could cut the webinar short right now if the answer to that was no. I think the reason why this matters, and you're absolutely right, this is a EU piece of legislation which is only going to, which is in force for all the member states of the EU, of which of course the UK is no longer one. That said, there are some important pieces of drafting in the legislation that give it what we call extraterritorial effect. So it's in a way the ability for the EU to reach its long arm outside of its over the channel, if you like, to effectively become enforceable outside of the EU. And there's various mechanisms within the legislation that allows for that to happen. So that's kind of one reason why it matters it matters for us, and it matters now. There's another couple of reasons really. One is that we know since 2016, with GDPR coming into force, how much that has driven compliance globally in the data protection space, and how even outside of the EU, GDPR principles and mechanisms and concepts have kind of found their way into local law around the world. And I think the EU is very much hoping this has the same effect, the so-called Brussels effect, which basically drives this act as a global standard for the world. And then finally, I think just politically, and through gravity, that because the UK finds itself on the doorstep of one of its biggest markets, it is just going to be a matter of fact and reality that a lot of businesses are going to want to make sure that, especially in the technology sector, that their offerings are compliant with EU law, because otherwise they're going to risk potentially having to say goodbye to one of their biggest potential markets. So for all of those sorts of reasons, and indeed Labour have indicated that they're looking to potentially work closer with the EU if and when they get into power later on this year. It's possible that they might find that AI falls within their security label for working closer with the EU. Therefore, there may be scope for that to creep in that way as well. So I think it's beholden on all of us really to kind of get our heads around what this act says and does.
Yeah, so it's relevant globally, isn't it, for everybody? This situation, it's going to be setting a precedent for other countries too.
Exactly.
Okay, brilliant. So let's have a look at some of the key principles. So what it actually is. So I did a sort of a very brief carousel covering sort of what the types of risk, which we'll look at in a second. But if you could just talk us through just an overview as to what it's about, what's its purpose.
Sure. Well, as I say, it is trying to give a framework to allow businesses to start both developing AI-enabled solutions and using them, and trying to do that in a way which sort of gives humans the ability to have some control over the outcomes. So some of the key principles in the Act are around defining what AI is, and it has quite a broad but generally accepted definition of AI systems, which is all around machine-based which have explicit or implicit objectives, and inferring from input data and generating outputs, which could be predictions or content, recommendations or decisions that can influence physical or virtual environments. So those sort of inputs could come from a human, or they could come from another machine, like an autonomous vehicle. And so it's very much around outcomes as a concept. And so the majority of the Act talks very widely about these systems. These AI systems depend on AI models, and it's the LLMs and other AI models that underpin the system. But for the most part, the Act is talking about the systems themselves and the developers and the users of those systems.
Okay.
And I think so I think that's probably enough on that point.
Okay, and then so I noticed when I was sort of looking through overviews that transparency and accountability are absolutely huge. So could you talk a little bit around that?
Yes, sure. So depending on, and we'll come on to the highly complex nature of this Act. I mean, it runs to sort of 200 odd pages. Unlike GDPR, when you were dealing with effectively three types of data: personal data, sensitive data, and non-personal data, you've now under the AI Act, you've got effectively 6 different types of AI to look at when it comes to thinking about obligations and transparency and accountability. And you've got 5 or 6 different roles, two of which we'll come on to in a minute. So you can see there's this really complex network of overlapping obligations. I think that in itself is going to be a challenge for businesses to implement the necessary requirements to adapt for. But the main onus of the Act is to drive transparency, i.e., to make sure that humans trust AI, or to certainly give the ability to make sure that humans have information to make informed decisions about where AI is being used and may be affecting their lives. So it's all around documentation, technical documentation, how it's all of this having to be put into the public domain, conformity declarations, and that sort of thing, which will have to be made public and will need to be made available to all of the supply chain.
Okay, great. And so, and I apologise again, as I say, I think we're still having a few problems. I think on your side, Piers, with the a little bit of static and fuzziness, but I think we're getting most of what you're saying. I think I'm hearing what everybody else is hearing. So, I think, yeah, let me know if anybody's having too much of a problem. We'll see if we can change it. But I think I'm getting most of what you're saying.
Is it worth logging out?
Do you have headphones at all? Because I think headphones might fix the problem. I think it sounds like it's something that's moving when you move. Could you go try taking them out? Would that work? That might be the problem.
Sure.
Yeah, if you go with that and undoing those, that might help. Is that okay? Are they out? Should we try that again? Can you hear me, Piers? Okay, I think.
I can hear you. I'm just
okay. Did you unplug them? Oh yeah, Rodo's thinking looks like a connection problem. Maybe we'll go for. Should we go for cameras off? See if that would help. Let's go. Sorry about this, everybody. We're just gonna make sure you're giving us so much value. I want to make sure that everybody can hear. Okay, maybe if I'll remove myself, that'll probably help a little bit with bandwidth. So I think I wonder if you can still hear me when I'm removed. I'm not entirely sure. The problems with live, so we just want to fix this because I don't want people to be missing what you're saying, Piers. Maybe when I tell you what, when you next talk, I'm going to remove myself and see how that helps. So yeah, one of the big things is about safeguarding without. So it's that finding that balance, isn't it? Really between kind of protecting humans but not stopping the rate of innovation. It's a really, really important balance to make, isn't it? With all of this, we don't want to kind of grind everything to a halt, but we also don't want the world to blow up on us. Oh, I think he's gone. I think he's going to come back. I was about to say I'd sing you all a song, but you don't want to hear my weird. We don't want to hear my voice generally, but let alone when half my face is numb. Has anybody got any questions I might be able to answer while we're here? I think we've got. I'm just going to go through. We've got a couple of questions already that I can look through. I would really, really like a cup of coffee, but I know that I'm going to. When you have a numb face. I always think I need a bit of music or some form of video that I play in the middle of these sorts of things when things go wrong. Okay, we've got a few questions coming in. Brilliant, thank you, Ilias. I think, yeah, yes, that's it. That's one more for everybody else, really. If I stick that up on the screen. Yeah, it's gonna, and I think that's what this is about, really, isn't it? It's that different, everybody collaborating. Yeah, if any views, in fact, that's something people can talk about as well in the comments if we've got. And Meta AI's open source release. That would be really interesting. So I think we've got Piers is back. Thank you for bearing with us. I'm just trying to get him connected again, but I think he's coming through now. Hey, you're back.
Hi.
Hi, okay. So what I'm going to do is when you next speak, I'm going to disappear. I think we've got a bit of like, technology, the irony of all of this. Okay. But yeah, I think I can hear you, but we've got a really big lag. So whenever I talk, there's probably maybe 5 seconds from when you answer, and I think that's what everybody else can hear. So if we go on to the next slide, because we've got some risk, I'm going to talk through a little bit of the next slide, I think. because this is a bit that I understand as well. So, oh no, not that one. Sorry, that was risk. Let's go on to. In fact, I'll sit back on this one. Let's talk about the two roles of provider and deployer, and I'm going to disappear off the stage for a second.
Okay, and apologies for the technical glitches. So yeah, Heather, the main two roles within the AI Act that are identified, there are actually sort of 5 or 6 of them, but the main ones for our purposes, I think today, are looking at the provider and the deployer. And the provider really, for provider, read the developer of the system. This is the person who, obviously develops the system, develops the interface, and then puts it on the market. And then the deployer effectively is the user. So that is the corporate or other end user for the system, and the one who actually starts to use it in a live environment. And why this matters is that the obligations for compliance under the EU Act fall primarily on the provider, because it's the provider that is able to give the necessary information about how the AI model and how the AI system has been developed. And then in turn, it is for the deployer to make sure that the provider has actually done what it said it was going to do and give the necessary technical information, so that when it is when it is using the tool and putting it in a live environment with potential humans being affected, it is able to provide the necessary information about how decisions have been arrived at.
Okay, great. And when we were talking about this before, we spoke about people being both provider and deployer as well, playing both roles.
Yeah, exactly. So of course we now know that, for example, with ChatGPT, people have been very quick to make use of the LLM and start developing their own versions of ChatGPT for their own internal uses. And of course, the lines between the two roles become at that stage quite blurred, and that adds another area of complexity as to whether you're a provider or deployer. Well, the chances are you may well, if you're integrating it into your own workplace and your own systems, you may very well be both.
Okay, and yeah, I think what you were saying, if you thought GDPR was complex, hang on. What did you say? Hang on to your hats, because
buckle up. Yeah, buckle up. Hang on to your hats. Yeah. No, I think there's so many sort of different facets to the matrix to kind of find out where at any given stage you as an organization might sit, and therefore identifying your compliance obligations. It is going to be a challenge and a major change management project needed, I think.
It's the sort of thing you need lawyers help for, isn't it?
I couldn't possibly say.
So I think risk. This is something I'm able to talk around as well, because it's something I looked into. I found it really interesting as to where the different tools are going to be placed. What's in which risk, which category. So there's very broadly, as I say, it's much more complex and nuanced than this, but very broadly, you've got these 4 sort of big categories, and there's a couple in each one. But unacceptable risk, which has, it's just not allowed, not permitted. High risk, which is very highly governed. Limited risk and minimal risk. So let's go through a couple of examples of those. So unacceptable risk. So those are the ones placing a significant threat to people's safety and rights, and they are banned completely, strictly prohibited. So anything around sort of social scoring by public authorities, judging people by behaviour or the traits, real-time biometric identification in public places. So those sorts of things off those kind of films when you think, oh my God, is the world going to become like that? Hopefully that, they'll be prohibited. What other sort of thing is in unacceptable, Piers?
Well, I mean, you've obviously touched on a couple of those, but I think things like trying to manipulate behaviours and what the EU calls circumventing free will, I think are the areas where they're just a complete no-no. Social scoring, so this is sort of thing that happens in China, where people get access to public services based on their social score. That is unacceptable. An AI that exploits vulnerabilities such as age or disability or social or economic circumstances So I think it's the sort of thing that you probably would know when you saw it.
Yeah.
But one of the examples I struck me the other day was watching that great film Minority Report, where predictive policing, whereby trying to arresting criminals before they commit the crime on the basis of in this scenario, or this analogy, AI and AI prediction, not allowed. That is different, by the way, from the ability to use AI for facial recognition in a anti-terrorist capacity. And this is something that was pushed for enormously by the French, actually, with the Olympics coming. So being able to use cameras, for example, in crowded places to identify the shape of a rucksack potentially being a danger.
Okay. Yeah, Minority Report, fantastic film, by the way. When we spoke about this the other day, I was thinking that's what I'm going to watch this weekend. But yeah, it's a really good example, actually. And then we've got high risk. So at using AI within sensitive sectors, so yeah, medical, obviously, and the rules for that rigorous. I can't say rigorous assessments. My R's I thought S's were bad. So, yeah, medical devices, recruitment tools, credit scoring, that type of thing. Tell us more, Piers, because I certainly can't.
Yeah, sure. Let's have a go. Probably this is, for our purposes, this is where we should be concentrating our sort of focus from a compliance point of view, because I think this is where the work really has to be done in terms of identifying high risk. So the Act does give 8 examples of tools or systems rather that may fall within this category, but there's an overarching kind of catch-all, and it's all around significant risk of harm to health, safety, or fundamental rights, or materially influence the outcome of decision making. So, for example, in education, using AI to do grading, to do exam marking, employment, you talked about recruitment there, but hiring and performance reviews, task assignment, critical infrastructure, so AI being used, for example, for traffic lights or dams or river flow, law enforcement, border control, administration of justice, that sort of thing. So those are all going to be high risk categories, high risk types of AI. And as I say, that's where the broad focus of the compliance burden falls. And so developers of these systems are going to have to do a lot of work in generating technical documentation before they put the thing on the market, to make sure that they're compliant. So they're going to have to do what's called a fundamental rights impact assessment. They are going to have to do, as I say, register on an EU database, carry out data governance requirements all around the model before it goes on the market. And then if you're a user of this, if you're a user of this sort of tool, it will be incumbent on you as a deployer to make this information available to your own the folks who are being affected by this AI.
Okay, yeah, and again, that brings out the transparency and accountability.
Yeah.
By the way, I'm picking up questions from people. We've got a little Q&A section at the end, so I'm storing those up. By the way, we're getting quite a few in.
Great.
Okay. Yeah. So let's move on to limited risk. So this is where we start to recognise a few of the names that I certainly use a lot every day, and I know a lot of people on here recognise a lot of names that I speak to. So this is a big chunk of the tools we use now. So rules of transparency to make sure users know they're interacting with AI. Because I was thinking when we initially started to talk about this, how many times are you speaking to a chatbot and you wonder, am I speaking to a real person or AI? It's going to prevent against that type of thing. But then it's kind of, you think about how far is that going to go? That's one of my questions for you, Piers, is something like, if a marketing agency was using AI, do they need to disclose this to their clients if they're using ChatGPT or Claude in the ideation process, and then they use, say, human copywriters? At what stage would they need to disclose their use of AI? But yeah, within this limited risk, chatbots, so ChatGPT, Claude, Gemini, all of those, Copilot, image gen tools, so all Midjourney, Runway, video gen. So a lot of the generative AI tools, the day-to-day, seem to fall within this limited risk section. Yeah, what do you think about kind of being disclosure in this sort of situation?
Well, and disclosure actually is the key to this this category, because the limited risk category is all around trying to stave off impersonation risk effectively. So being very clear that this is an AI tool that you're interacting with, and that's the main focus of this. So it's the transparency requirements on this one are easier perhaps than complying with on the high risk, but nevertheless you need to be able to demonstrate and be clear and transparent with end users that you're interacting with an AI tool.
Yeah.
I mean, some of your specific question about for agencies, I think that's less an issue of necessarily the AI Act, because I think you're probably going to be potentially at a more minimal risk end of the spectrum there. But from a client relationship point of view, and certainly we're finding that clients who are involved in the creative industries, they are being required by their clients to be very clear with their clients about when they're using AI tools.
Yes, actually,
for reasons outside of this legislation, it's to do with IP and infringement, etc., and originality and reputation.
I've spoke to an agency a couple of days ago that have a very big brand client, and that client has prohibited them from using any form of AI in their creative work. And I just wondered how on earth they could enforce that, and what do they mean? It could be somebody, like strolling around the park talking to ChatGPT, coming up with ideas that then become the main kind of focus of that campaign. At what point is it? It's so hard to enforce, isn't it? Because it's something that we use personally, not even necessarily within the workplace.
Yeah, exactly. And maybe it's there's a halfway house here, and we're sort of slightly getting off track. But it's an ideation place rather than a actual production environment. So you get the ideas, but and inspiration.
And then we've got our final category, so minimal risk. So that's the rest of them. So very minimal rules to encourage innovation. So we're talking AI-enabled video games. You've got some really exciting ones where they'll respond to you. Characters will respond to you as you go in, and it's a different conversation every time. Spam filters, been around for ages. Our beloved spam filters, but where would we be without them? And AI tools for photo collections, a few examples. Anything else to say around this minimal risk section?
No, so that's it. I mean, that brings us to 4 categories of risk. And as you say, I think the EU is expecting most of our day-to-day usage of AI to fall within the minimal risk end of the spectrum. Okay. But that brings us on to the next slide, which brings us kind of back into compliance, which is around generative AI. And this is what has made the Act even more complicated, because initially, when the legislation was going through, there was no mention of Gen AI within it, because actually at that stage, as I said, no one had really heard about it before November 22. And so when this appeared on the scene and just took the world by storm, this sent the legislation into a little bit of a spin, I guess. And there was a lot of political debate about whether it should be banned or really heavily burdened by compliance. And in a way, they sort of fudged it, because they've just introduced this generative AI definition, which actually cuts across all of those risk categories that we've just talked about. So that obviously you could have a high risk or prohibitive risk Gen AI, you could have a limited risk Gen AI, and some of the examples that you gave there were just that. And so there's again within this category, if you're looking at general purpose or generative AI, it is going to be looking at the models and making sure that the developers of those models give the right technical documentation about how they've developed the model, how they've trained it, they are compliant with EU copyright laws, that sort of thing. That's for sort of all purpose. And then there's there's a subset of this, which is the systemic risk Gen AI, which the EU sees as potentially being so powerful that they get incorporated into the value chain, into the supply chain, and therefore it's really important that everyone knows exactly what it is and how it works. And so there's a higher level of compliance requirements on those sorts of developers.
Okay. Stuff. So this is something I keep on being asked whenever I mention, and when I did my little carousel a couple of weeks ago on this. How is it being enforced? Who's enforcing it for a start?
Yes, again, good question. So I think obviously this is say an EU act, and it will be enforced by the EU within the EU. So as things stand in the UK, the ICO, you might expect the ICO or another competition authority over here will not be enforcing this law. But in the EU, they will be setting up, either using the existing data protection regulatory authorities or setting up new AI regulators to regulate the act. And then there will be an AI office which will drive technical standards, and there will be an AI board which will look to harmonize the application of the law across the EU. In terms of what happens if you're outside of the EU and you're not compliant with the law, but nevertheless, because of this extraterritorial function, this long arm, as I mentioned, you find yourselves actually being caught by this act. The obligation is much like the GDPR. You are meant to appoint a representative within the EU, and it is that presence that will allow the EU to enforce, or the regulators rather, to enforce the act against you. The big difference between this act and the GDPR, which struck me actually, Heather, when we were chatting the other day, is that with the GDPR, arguably one of the major drivers for compliance has been the rights for individuals, you and I, to take action against organisations that haven't looked after our data in a way they said they would, or against the law. Social individual rights. There is none of that in the AI Act. The only rights for individuals to have any kind of effect here is to complain, and they have a right to get an explanation where they may have been affected by an AI decision. There is something called the AI Liability Directive that is not yet on the statute books, and if it ever does come on the statute books, again, won't affect us here in the UK because of the nature of that legislation. It's very much EU focused. Okay. And that would give people rights to bring claims, but again, in the EU and not necessarily in the same way that GDPR does.
Okay, and what about the penalties? Are they similar to
GDPR? Yeah, penalties will be familiar to us. It's a percentage of global turnover. So depending on who you are and your level of and the AI model that is involved. So higher risk models might attract higher penalties, but you're looking at 1% of global turnover up to potentially 7% for example, if you were to be a developer of a prohibited system, you could be looking at 7% of your being fined for your global turnover. Okay. There's a range.
Yeah, hefty. But then we've always got
hefty.
We've always got won't it, and we spoke about this before, didn't we? It's perfectly possible it could be just ignored, like anything else.
Yeah.
Exactly. Some people might not even have the representative as they meant to. It's it's a scary thing.
Well, it's like not everyone absolutely follows the letter of the law of GDPR, and I expect that there will be probably some high profile cases coming along quite quickly, which will be designed to shine a light on the regime.
Yeah, somebody's going to be made an example of straight away, aren't they?
Yeah. And the big players are global players, so they will have presence in the EU anyway. So that's how they will be forced to comply.
Yeah. Okay. So practical bit. What should we be doing now? What's your advice as to businesses? We've got businesses of all different shapes and sizes in this live now. So what would be your advice of practical things we should be doing now to prepare?
Sure. Well, I mean, hopefully it's been clear from over the course of the last half hour or so, despite the glitches, that this is a really complex piece of legislation. And in order to know what your compliance obligations might be under it, you need to know what AI you're using. That's so the first step in all of this is going to be doing an inventory of your estate, IT estate, to see how you are using AI, how your suppliers are using AI, how your own customers might be using AI. And once you've carried out that, you can then begin to see, well, am I within a, let's assume it's not prohibitive, is it a high risk or is it a limited risk or no risk scenario? And then once you are able to identify that, obviously it's over to lawyers, dare I say, change management, project managers, potentially, data protection, because there is a lot of overlap. And in our experience, I think we're finding that the governance around AI does tend to find its way back to the data protection officer or data protection manager within an organization, simply because, well, it's all data. So we'll just let them do it. It's actually much wider than that, but nevertheless, you do need a governance champion, I think, to kind of be an expert within an organization, to kind of be a centre of excellence, to be able to advise the business on what they should be doing. So once that inventory has been done, it's then a question of working through the steps and working out what documentation you need in place, what governance requirements need in place, making sure your contracts are in a good place in terms of making sure things are flowed down correctly, or if you're buying an AI, that your provider, potentially the developer, has given you the information you need. And I think there's going to be a little bit of Wild West about it initially, because unlike with GDPR, we've had 6, 7, 8 years of working out where people's roles and responsibilities lie, and as a marketplace, where the liabilities should lie. I think there will be quite a lot of toing and froing in this area, where you've got developers saying, this is a general purpose piece of AI, but actually we don't want you to use it for X, Y, and Z. And you've got the users, you've got the purchasers of that system going, well, we want to use it for ABC, and also I want warranties from you that you've done what you should have done under the Act. There's going to be a lot of sort of toing and froing, I think, around that, but it's a big challenge. But the starting point is the inventory, and also obviously identifying what your role is within that supply chain, whether you're a developer or user deployer, and there's mapping a process and a continual process. It's not going to be a one and done thing. It's going to be something that's going to need, because I suspect most businesses are going to be picking up these tools left, right, and centre without potentially too much thought or oversight. So it's trying to get an oversight of the entire estate and making sure that you've got policies in place which educate people, educate your staff, educate your users about what is acceptable and usage of AI and what isn't.
Yeah, I think AI tools, these websites are going to have to become a little bit more informative as well. I think they're really excellent with their landing pages and their selling of the tools, but not explaining sort of as their role of provider. Is it provider? To how they were made and what they're for and where everything's used and all of that sort of type of thing too. So I keep on thinking about something we spoke about with the AI note takers, because that's something like the consent around that. But there are so many different companies that we've never heard of before in this world that are coming in, and we're kind of inviting them into meetings and we're using them with sensitive information. It really is a Wild West at the moment. So yeah, there's a lot to think about. Okay. So we're going to move on to a bit of a Q&A. We've had lots of questions as we go, so I'm going to work through a few of them, pick a couple of them out for you two. So I'll put them on the screen for you. Okay, let me just pick one. So there we go. So from Ilias, how do you foresee the EU AI Act shaping the competitive landscape for businesses in terms of innovation, ethics, and market dynamics? And what strategies are you considering to adapt and thrive within this framework? Big question, Ilias.
Thanks, Ilias. Not warming me up there at all. I'll just go straight in with the big ones.
Straight in.
Okay, so yeah, The honest answer is, who knows? I mean, I haven't got a crystal ball, but certainly the real concern for the legislation in the EU is to strike a balance to allow protection of individuals, protection of humans around outcomes from AI, with allowing innovation. And a lot of these big AI players are springing up in the EU as well, particularly in France. So they have a real vested interest in making sure it's not the regulation is not applied in a way which is a dead hand on that innovation. But I say in terms of competitive landscape, I think I know it's the UK government's hope that the UK forges a lighter touch approach to regulation around AI. My personal opinion is that is probably a bit of a fallacy. I don't actually think that it's possible for us as an island looking for a global market to be able to comply with our own law when we're looking to sell technology and export technology around the world. So, and I think, as I say, as the EU Act is going to more likely than not, to a lesser or greater extent, become, or the principles certainly will get rolled out, I would say, around the world. They will get adopted. Whether in this way, 500 plus pages, and the complexity of it is another question, because that actually is phenomenally complex, and it may be that means that it doesn't get rolled out throughout the world. But I think the principles of it may well do. I think so for UK businesses, for example, the reality is that they will just raise their game to the highest common denominator in terms of their business and their solutions. So I think that competitive marketplace in the UK with this light touch regulation is probably an illusion. And I think the straws in the wind, to my mind, do seem to point towards more regulation even in the UK in this area. I mean, you've got Ofcom beginning to talk about regulating generative AI now. So yeah, I think all of that, and yeah, ethics as well. You mentioned that. I think yeah, I mean that is the key, isn't it? I mean, we all want to be ethical in our use of AI, and I think what the Act has tried to do is try to codify some of that. And it's a starting point. I think we should all be seeing this as a first attempt at putting a marker in the sand to regulate AI before it's too late. And we should be seeing it as if this isn't the end point, it's certainly but it is the beginning. And I think that we need to see it as such and work towards. It's a good first attempt at trying to codify the law around AI.
Okay, great answer to a big question. Okay, so there's a great one from Daniel here, actually. Do you know how quickly the EU has moved with this legislation? You were saying it's a little older than we think. Is it faster than previous legislation? Seems to me that governments are usually several years behind the curve, but in this case, it looks like they're moving pretty quickly. Or is that just me?
Daniel, I think so. I think it actually is quicker. I think it is a quicker process than I think GDPR to get onto the statute books was 8+ years. So I think this since 2021, obviously that's three and a bit. I think there has been a real impetus to get something on the statute books, and no doubt given enormous impetus by ChatGPT launching in November 22. I think the approach perhaps is the fact that they suddenly had to, when it came out, bolt on this bit about Gen AI when it hadn't previously been there, shows that that there are potential problems. Because I mean, they're always trying to define something ahead of it. Actually, they're trying to future-proof it, but then suddenly having to make a big change just when something comes out on the marketplace, that does actually shine a light on how difficult it is to properly future-proof these things. And who knows what the next few years will bring in that space.
Okay, thank you. Rodo, the lovely Rodo, said, would the EU require providers, I don't know whether you'll know this, provide the list of training data that models have been trained on? So a lot of people ask this, how how are they going to deal with that situation?
Yes, that's right, Rhoda. Thanks. Yeah, absolutely. That for the LLMs, for the Gen AI, that
Yes,
they will be required to give technical details about the training data that's been trained on, and that it's been properly licensed and in compliant with copyright law.
Okay.
Good question. Yeah.
Helen, you know Helen. What about the provider deployer issue if you're making custom GPTs for client use that you're training to start with? It's that multi-role thing, isn't it?
Yep. Yeah. So Helen, I guess if you're an outside provider looking to develop a GPT for a client for their own use, you are going to be in the first instance a developer, the provider, and your clients will be very keen to make sure that you've done what is needed under the law, and provided the necessary technical documentation that they need to be able to use it downstream. Hopefully that answers your question, but if not, do come back. I mean, if you're talking about, I'm just looking at the question here. If you're talking about the data and it's their data, that's fine. It may well be their data, but that doesn't necessarily in and of themselves make them a developer. They will be the deployer, assuming that the development is always done by the outside agency.
Mm-hmm. It could be an
but if they start
chain.
to bring it in-house, and exactly, yeah, and actually the reality is that there may be a lot of tuning. And query, this is what I don't know actually, is query is if the client is giving the outside agency, outside supplier, quite detailed instructions about the development of the ChatGPT, of the model and what it wants it to do, it may be that the lines become even more blurred.
Yeah. Like you say, it's a starting point that we're at, isn't it?
Yeah.
It's so much. I think things change so quickly.
And in fairness, that we have the law, but we don't have there is a code of practice coming, which the EU has to produce within 9 months. So by the end of this year, which may help, may not.
Yeah, it could muddy it further. That's a great question from Luke here. So do you think businesses should have an AI statement or policy on the website, a bit like T's and C's or privacy policy? I think it's a great idea.
Yeah, excellent. I think they're going to, I think that's right. If they're users of AI or their products have AI incorporated within them downstream, I think it will be absolutely standard to have a section on how the AI has been developed, where it's come from, what it was trained on, and just an ethical statement as well, and how it works. I mean, as a transparency issue, it's going to need to talk about exactly how the data how the training data has been used, and how the decision, assuming we're talking about decisions here, how the output has been generated. Mm-hmm. So yes, I think that absolutely that will become standard.
Yeah, I agree. That's something I'd really like to do myself. Laura, by the way, I got your message, Laura. Reply to you just as a note. Will the enforcers be held to the same regulations? I think it's more of a kind of opinion here. I just imagine they haven't said this. So imagine they'll need some AI capabilities in order to detect misuse.
You would hope so. I mean, EU regulators are subject to EU law, so you would assume that is the case. I mean, I didn't touch on, there are exemptions to some of this around, sort of research and development and that sort of thing, or personal use AI. That those sort of are outside of the ambit of the Act. But yeah, I mean, there's no carve out for the regulators themselves being able to do what they want.
Yeah.
As I say, there are specific examples for law enforcement, but that they're really tightly prescribed. It's very specific and subject to a lot of checks and balances in terms of how they can use that stuff.
Okay. A bit more of a practical question from Susie O'Neill. Where would you go to stay up to date with the latest news and advice on the AI Act? Is there a specific place that you trust to go? Is it direct to the source? Where would you go?
Yeah, I just follow sort of lawyers on LinkedIn who have been sort of on this. There's a really good journalist whose name escapes me, who I follow, Phil Lee on LinkedIn. I follow Eduardo Restaurant is really good on this. So yeah, there's a few really good lawyers out there who.
And Piers Clayden, of course.
And of course myself. Yeah. I can't say that.
I can. Okay. So yeah, recording. So Matt, yeah, a recording of this session will be available as it's live. It will come back. But if anybody does want a recording of this session, please just drop me a line, heather@nontechies.ai, and I will sort you out an actual file. There's just a couple more. We've got just a few more minutes. Let's have a look. Explainability statements are already popping up on some companies' websites, people have said. Okay. Shady Shaker, there is no clear specification for each requirement in the AI Act. So how will the conformity assessment be conducted? So yeah, how will people determine? This is how I read this question. How will people determine which level of risk you're at?
That's where the lawyers come in, I'm afraid.
Okay.
Yeah, I think it is going to be that ultimately that's where it's going to be a decision, because it is a legal issue, this risk, where it's the interpretation of the act, and that's where I'm afraid lawyers will need to be consulted to say, well, looking at this tool, we think it's at this end of the spectrum or this end of the spectrum, or and inevitably there may well be areas where something falls between the two. As I say, I think, having said that, I think for our purposes, in general commercial scenarios, and we've been through the high risk list, I would say the examples that fall within that high risk list are going to be sort of few and further between, for general everyday use of AI. But obviously for organizations who are very much using it a lot, then that's a different kettle of fish. But Shady, the actual conformity assessment that has to be registered with the EU's AI office, there is a specification for that.
Okay. Yeah, it just gets muddier and muddier, doesn't it? Particularly when you were saying about personal use as well. That's how the line between personal use and professional use.
Yeah, sorry, the actual wording is, just to be very, very clear, it's non-professional capacity.
So, non-professional capacity. Okay.
I sort of take that as
yeah. I think I don't know what working for myself. There's no line between professional and non-professional. I don't think everything I do in some way contributes to my business. So
yeah.
I think we got one more question here from Monica. Hello, Monica. What is your view on Meta's open source release?
View. Well, I think the fact that it's open source does take at least some of this outside of I think there are exemptions for open source. Some of the compliance obligations for open source AI are outside of the Act. And other than that, I don't really share a view. I mean, my thinking with open source AI was back in the day that the fact that it's open source means that it should be easier for people to comply with transparency requirements, because it's not a black box, and therefore folks will be able to actually interrogate and work out exactly how the AI operates, because it's there, it's open. So I think that's a good thing, but I'm afraid possibly that's not enough. Given your question, I suspect you're looking for more detail on it than that, and I'm sorry, I can't provide it.
Well, we opened and we finished on a tough question, didn't we? Just keep you on your toes. Just one more thing before we finish. Piers has very, very kindly offered free 30-minute consultations. So how often do you get 30 minutes with a lawyer for free? Not very often. So if you're looking for help, particularly if you're a tech company looking for help with your AI or with your contracts or with anything to do with legal work, Piers is absolutely fantastic. So if you want to email him directly, and we'll also be sending out a link to all of the people who've attended. So thank you very much indeed, Piers, for your time. You've been fantastic. So much value. Yeah, really, really
You're
useful.
welcome. Thank you so much for having me, and thanks everyone for joining in. I do apologise for the glitchy first third, but hopefully we got there in the end.
We did, and I apologise as well for my inevitable slurring and weirdness on this.
Between the two of us, yeah.
We got through it in the end, didn't we? Okay, thank you very much, everybody, and yeah, we'll see you soon. Thank you.
All right. Thanks everyone. Thanks, Heather. Bye.